My name is Carla from Homecare Realty. Today, we will be answering some questions regarding property management. Let's start with question number 1. What actions can be taken if a landlord or tenant is breaking the law? It depends on the situation. You can put the concern in writing and provide a letter or email to the other side. The other person may not have been aware of the law. If there has been a breach, you can make an application through the Provincial Court Civil or the Residential Tenancy Dispute Resolution Service. If a landlord or tenant commits an offence under the Residential Tenancies Act, you can make a complaint through Service Alberta. There may also be other options depending on the situation. If there are repair or maintenance problems, you can contact Environmental Public Health for more information, or call HealthLink at 811. A health inspector can conduct an inspection and issue different orders. For example, an order might say that the landlord must complete repairs within a set period of time. Question number 2. A tenant did not move into a property, but already paid an application fee to the landlord. Can the landlord keep the money? The Residential Tenancies Act does not prohibit landlords from charging application fees. If there is an application form, the tenant should review it carefully before signing it and handing over any money. If the application form says that the application fee is non-refundable, then the money will not be paid back. This is the case even if the tenant decides not to move in or if the landlord does not accept the tenant's application. Question number 3. FAQ. What happens if the terms of the lease contradict the Residential Tenancies Act? The Residential Tenancies Act always takes priority over a lease. This means a lease cannot take away any of a tenant's rights under the law. For example, a lease says that the landlord only has to give 2 tenancy months notice to end a month-to-month periodic tenancy. This term in the lease is unenforceable because the Residential Tenancies Act says that landlords must give at least 3 months notice. Question number 4. FAQ. Does the lease have to be in writing? In Alberta, you do not need a written lease. However, a written lease is a good idea because then both the landlord and the tenant are clear on their responsibilities. If there is a dispute later, having a written lease can help clarify what was agreed to by both sides. A written lease is also important if the landlord chooses to sell the property. The new landlord will have to follow any written agreement that was already in place. Also, if the lease is in writing and the tenant has signed it and given it back to the landlord must give the tenant a copy of the lease with the landlord's signature within 21 days. If the landlord does not do this, the tenant can withhold rent until a signed copy is received. This is the only time that the Residential Tenancies Act allows a tenant to withhold the rent. Question number 5. FAQ. Can the landlord or tenant ever break the lease? Substantial breach. There are certain situations where a landlord or tenant may be able to break the lease or end the lease early. If the tenant or landlord has committed a substantial breach of the residential tenancy agreement, a 14-day notice can be served to end the tenancy, or an application can be made through the Residential Tenancy Dispute Resolution Service or Provincial Court Civil to end the tenancy. See our pages on eviction notices and tenant's 14-day notice to terminate tenancy for more information. Personal circumstances. If a tenant wants to break the lease early because of personal circumstances like lost job or relocating for work, the tenant should talk to the landlord and see if the landlord will consent to ending the lease early. The landlord is under no obligation to consent to breaking the lease, but might be willing if the tenant agrees to help with advertising and making sure the suite can get rented. If the landlord agrees to break the lease early, the tenant should make sure this agreement is in writing and signed by the landlord to prevent any problems in the future. A landlord cannot break a tenant's lease and make a tenant leave the property before the end of the lease. A landlord can ask the tenant to consent to ending the lease early, but the tenant is not obligated to do so. Question number 6. FAQ. Can the landlord require a tenant to provide proof of insurance as a condition of the lease? Yes, a landlord can require a tenant to have insurance as a term of the lease. It is up to the tenant to agree to that term. Tenants can try to negotiate this term with the landlord. A basic tenant insurance policy will include liability coverage. This helps tenants with situations where they may be at fault for damage to a third party, another suite, or the building. For example, if a fire starts in the tenant's apartment and it damages another suite, liability insurance will help cover the costs of the damage to the tenant's unit and the other suite. Tenant insurance can also include contents insurance. This helps cover the replacement cost of the tenant's goods and personal items destroyed by fire or water damage. The landlord's insurance does not cover a tenant's items. Question number 7. FAQ. Does everyone who is living in the property have to be named on the lease? A landlord usually requires that everyone who is living in a rental unit be named on the lease. Landlords have the right to know how many people are living in the rental unit and who is living in it. This information is important to ensuring the minimum housing and health standards are met. If a person is named as a tenant on the lease, that person is subject to all of the rights and obligations of a tenant under the Residential Tenancies Act. For example, if Joe and Beth are both named as tenants on the lease and they do not pay their rent, the landlord can choose to collect the rent from Joe alone, Beth alone, or from Joe and Beth. Where someone is named as a tenant on the lease but has not signed it, they still have rights and obligations under the Residential Tenancies Act. If the lease includes rights and obligations outside of the Act, the tenant who has not signed the lease may not be subject to those provisions. For example, if a lease gives a tenant the ability to end a periodic tenancy with a shorter notice period, a tenant who has not signed the agreement may not get the benefit of the shorter notice period. Question number 8. FAQ. The lease says that no pets are allowed. Is this legal? Yes. In Alberta, landlords can decide whether to allow pets in their rental properties. If a landlord does not allow pets or the building has a no pets policy, then pets are not allowed in the property. If pets are allowed in the rental property, the landlord may charge a pet fee. The fee must be reasonable, and the landlord should be able to provide the tenant with the reasons why the fee is being collected. For example, if the pet will be walking through the common areas, there may be additional carpet cleaning required.